moment is here with us. It is our expectation that this opportunity would afford all of us, the needed space to be able to appreciate in perspective a number of issues which are in the public domain. It will afford us the opportunity to be discerning enough to make intelligible judgments in furtherance of the building of this nation. I don't believe it's an opportunity to apportion blames or to put out there who is right or wrong. It is simply to give out information which is necessary for our national discourse. And in that regard, I thank you all for coming and welcome you all. I believe you all grant my thank you.
The Right Honourable Speaker, leadership of the House, honourable members, distinguished members of the media. They say when the old lady calls you, you usually do not know what they are going to say, so you will hazard all kinds of guesses until you hear from them. Usually it would be to give you nuggets of wisdom or to caution you about a direction to head in order for you to prosper in the land of the living. Our old lady, in this case a male, has called us and we've come. And so we are going to listen to him and hear what he has to say. Please, with a round of applause, help me to welcome the Speaker of the 8th Parliament of the 4th Republic, the Right Honourable Alban Bagbin.
Please, kindly be seated. I believe I'm too young to wear the hat of an old lady. I don't have that wisdom of the old ladies. Let me also add my voice in welcoming all of you to this afternoon presser, and I'll do all I can to be as brief as possible. Beloved guardians, democracy will work only if we fight for it, says President Barack Obama of the United States. I swore an oath to uphold, preserve, protect, and defend the Constitution of the Republic of Ghana, and that I will do right to all manner of persons in accordance with the Constitution and the laws and conventions of Parliament, without fear or favor, affection, or ill will. I concluded the swearing of the oath with a call on God to help me. I'm very confident and have faith in God to see me through these dark days of Ghana and our young democracy. Ladies and gentlemen, I want to start this presser by disabusing and setting the minds of Ghanaians at ease. There is no constitutional crisis in this country. I repeat, there is no constitutional crisis in this country. The Parliament of Ghana is alive and working. Let nobody mislead, misinform, or disinform you and the country. The democratic system we adopted and enacted, as captured in the Constitution 1992 and fleshed out in various laws, processes, procedures, and practices, is what has been triggered, and it is working. Let us allow it to work. Democracy is about the advance and earlier action he had commenced in the Supreme Court on the 15th of October 2024 to prevent the Speaker of Parliament from receiving and making any pronouncement on the subject matter of the statement made by Honorable Dr. Akufo-Addo until the final determination of the matter by the Supreme Court. The rest, we say, is history. Ladies and gentlemen, being a party to the suit in my official capacity, I am mindful of what I say. But it must be said, the suit before the Supreme Court raises not just legal questions, but more importantly, has profound implications for our democratic system of governance. At its core is the very essence of our democracy. While many legal arguments have been advanced in and out of the court, I recognize the fact that connected political and governance implications have not been addressed sufficiently to enrich the national discourse. It is my considered view this should also be vigorously articulated to give a holistic approach to resolving the issue. As one of the protagonists in this matter, and a long-time practitioner, it will be a disservice not to respectfully draw your attention to some of the facts, principles, and ethics of politics and governance, the practice and procedures of Parliament, and what is generally referred to as parliamentary law, to throw light on some aspects of the matter and to clarify the considerations that underpinned my actions. The current brouhaha may be likened to a power play between the arms of government, and it has the potential to undermine our democracy and the authority of Parliament. Its outcomes could subvert Ghana's constitutional order and the democratic system. Ghanaians have toiled, sacrificed their lives, and shed blood to establish for decades. Ladies and gentlemen, recent acts of the judiciary and executive, and I see them as interference in the workings of Parliament, pose a direct challenge to the essence, jurisdiction, authority, powers, and functioning of the esteemed institution of Parliament, which is the repository of the sovereign will of the people of Ghana. It is increasingly becoming clear the judiciary and the executive are seemingly colluding to weaken Parliament. The decision of the Ghanaian voters in the 2020 presidential and parliamentary elections is clear and loud to all discerning people. The decision is obviously a preference for a consensual and collaborative governance to a winner-take-all government. The majoritarian system of Parliament, where the minority have a say, but the majority have its way, was rejected by the voters. They rather opted for inclusivity, collaboration, consensus building, leaving nobody behind. The equal representation of the two major parties in Ghana, resulting in the composition of a hung parliament to the voters, is the better way forward for our dear nation. The expectation of the voters is this will lead to the constitution of a parliament where the national interest will prevail as against partisan or parochial interests. This is the context and the peculiar situation I have to preside over as a speaker. I'm the first speaker in the Fourth Republic, in fact, in the history of Ghana, to work with a president who belongs to a different party, to work without a majority party in parliament, but with an evenly divided parliament, 137, 137 apiece. That is a hung parliament. Decision making has therefore not been smooth sailing. As a Speaker of Parliament, I hold the balance in favor of the national interest, but sometimes bend backwards to accede to government requests because government has been given the mandate to govern. It is with this understanding I led the board of the Parliamentary Service and members of Parliament to provide procedural rules of engagement to actualize this goal and to provide for the possible types of government as envisaged in the Constitution. These possibilities include an election of an independent president to form a government, somebody who contests, as we have now, as an independent presidential candidate can be elected by the voters as the president of Ghana. How is he going to work with Parliament to get his or her business, that is government business, approved by Parliament? We have a possibility of a minority government where the voters vote for the president, but he has less members of Parliament. And that is a minority government. How is he going to get the majority members of Parliament to always approve his business for him to govern the nation? We can also have a coalition or a merger of parties government. And the familiar one we know is a majority government. These are possible governments constitutionally guaranteed in Ghana. In the current hung Parliament, the new standing orders of Parliament had to cater for such a government by a number of provisions in the standing orders. We also provided provisions for all the other options of government that I just explained. For instance, a day which we call a decision day has been designated in the new standing orders, where the Speaker, in consultation with the leadership of the House, will set aside to allow members of Parliament who are ministers and deputy ministers the the opportunity to be present in Parliament, to be counted in support of government position, to ensure government business does not suffer for lack of government members of Parliament in Parliament. Despite the above, often the number of government members present still don't add up due to the nature of the duties and responsibilities of ministers and deputy ministers. The NDC members of Parliament, however, understood the situation and on a daily basis cooperated with the MPP members of Parliament to see government business through. In spite of this, the NDC members are said to be saboteurs of government business by the MPP members of Parliament and the followers of the new patriotic party. Those of you who cover proceedings on a daily basis are witnesses as to how sometimes I have to look at the members of the NDC in a very stern manner, which made them give in to their objections, just to get government business going. Ladies and gentlemen, the powers of the judiciary ends where the nose of Parliament starts. The Constitution is very clear on freedom of speech and of proceedings of Parliament. Articles 115 and 116 grant members of Parliament privileges and immunity of speech, debates, and proceedings on any matter or thing brought by a member in or before Parliament by petition, bill, motion, or otherwise. And I want to quote the two articles to you. Article 115. There shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Article 116. Subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be initiated against a member of Parliament in any court or place out of Parliament for any matter or thing brought by him in or before Parliament by petition, bill, motion, or otherwise. This means happiness in Parliament must remain in Parliament. So the cause must and has always been hesitant to interfere in the proceedings and decisions of Parliament. In the celebrated case of Tufuo versus the Attorney General, the Supreme Court affirmed that happiness in Parliament are a closed book. Despite these provisions, the courts are replete with debates and proceedings of Parliament. Most worrying is these proceedings are initiated by some members of Parliament, even leaders of Parliament, who ought to know better. Parliamentarians who are to be loyal to Parliament rather than to the Supreme Court run to the Supreme Court at the slightest opportunity. to use the Supreme Court to undermine Parliament. This might be one of the reasons Parliament and members of Parliament are not respected and treated with disdain. This was exhibited by the President's refusal to even receive the LGBTQ+ bill, duly processed and passed by Parliament, without any legal basis. The judiciary is supportive of this conduct by the receipt and processing of a suit on this subject matter. These are dangerous precedents in our democratic journey. Both the President and the judiciary have sinned against the Constitution and must seek the opportunity to confess and repent to be forgiven. I am confident the battles we are fighting today will make our democracy stronger and more vibrant in the future. I believe in the supremacy of the Constitution. Mark my words, the supremacy of the Constitution, not the supremacy of the judiciary or Supreme Court. I also believe in a vibrant Parliament that is respected and accorded its due on political questions as long established by law and decided cases. A Parliament that understands, reflects, and embodies the will of the people and defends its constitutional prerogatives only works in the interest of Ghana and Ghanaians. Not a rubber-stamped Parliament subservient to the whims and caprices of the executive and or the judiciary. Again, I strongly believe that Parliament was one of the institutions President Barack Obama had in mind when he opened, while in Ghana in 2009, that Africa needs strong institutions and not strong men. I'm happy he didn't add women. Parliament must be strong to perform its legislative function and the indispensable function of holding the President to account. That is the oversight function. No other person or body has the gravitas and constitutional mandate to do so in Ghana. The public, media, civil society, and other partners in governance can make constructive inputs and criticize actions and commissions of arms of government. But these bodies are not constitutionally and legally structured and mandated to hold the executive to account. Parliament is elected. It is, at its best, the will of the people, legally and constitutionally structured and mandated to do so. Ladies and gentlemen, my dream, therefore, is a patriotic one. The existence of a firm, effective, efficient, and responsive Parliament, whose members place national and constituency interests ahead of narrow, partisan, or personal interests. At last, this is yet to materialize in Ghana. Parliament weakens itself when its members keep running to our courts to settle or seek favorable determinations of not just legal matters, but essentially political and governance questions. It is my strong belief the matter before the Supreme Court can be settled within Parliament through matured deliberations and compromises. Please, make no mistake. Not all the strong men President Obama warned us about come in military uniforms. Some come dressed in suits. I hope in my lifetime, Ghana shall have a parliament and a speaker who are truly independent from Jubilee or Flagstaff House or any headquarters in the conduct of parliamentary business. Let me state unequivocally, Parliament owes its duty to the people who established and elected its members to serve and represent them. The wheels of Parliament will continue to turn, and no person will be allowed to disrupt parliamentary proceedings or to undermine the democratic mandate of Parliament. When I ruled in January 2021 on the issue of which side constitutes majority and minority in Parliament, the ruling was in favor of the majority group then. It was not an act of lawlessness as to cause constitutional crisis. When I ruled in the matter of the vacation of seats by Honorable Kennedy Ajapong, Honorable Henry Korte, and Honorable Sarah Adjoa-Safo, the question of the interpretation of the Constitution was not raised. When my predecessor declared the former seat vacant in 2020, applying the same provisions of Article 97, the original jurisdiction of the Supreme Court to interpret and enforce provisions of the Constitution was not invoked. Peace reigned in these instances, and nobody cried and ran to the Supreme Court under the guise of constitutional interpretation. If I may ask, is it a legal matter for the Supreme Court to decide as to which side of the House constitutes the majority or minority? It is for good reason that justice is said to be blind, and further, that justice must not only be done, but must be seen to be done in all cases, not in only those cases to which some people appear to be sentimentally attached. Fellow Ghanaians, I respectfully call on the Supreme Court to apply the same swiftness with which the motion ex parte in the instant matter was granted to this model: government, opposition, benches, and a carpet in between them. And so, when you are shifting your political lineage, you have to cross that carpet to the other side. And that is why we have the term carpet crossing. Our parliament is not arranged in the form of government and opposition. And government don't like the term opposition. So we decided to adopt the terms from the United States of America: majority and minority. So you can even sit anywhere. But the numbers determine who is majority and who is minority. But in our parliament, the practice is for those who constitute majority to sit at the right side of the speaker, and those who constitute minority to sit at the left side of the Speaker. That is because after independence in 1957, we adopted the Westminster system, which is practiced in the United Kingdom. But we changed that, even to the extent that the arrangement of the floor of the House is in a horseshoe. So it's not always the case that the people to the left side are all members of minority. That's not the case now. And there's good reason behind this. As in the textbooks, the determination, therefore, in our situation, as to who constitute majority or minority, is a question of numbers. As to where they sit, is the determination, first, of the political parties, who influence who should lead the caucus or party wing in Parliament. They, after various consultations, decide that these 5 people should occupy these positions in leadership. And so they are given the chairs in front. Then in consultation with them, the 5 leaders, they determine who should sit behind them. Because as a leader, you need somebody that you have trust, confidence in, who has the capacity, so that when you are in some difficulty or you have a challenge, you can just lean over and listen to his or her whisper. So you have a say as to who sits behind you. The Speaker is not involved in this one. The whips, particularly the chief whips, lead in trying to identify who should sit behind. And it also has to do with years of experience in the House, and also the issue of gender and other professional backgrounds, until you get to those who are at the back. Even though we don't sit on benches, we still use the term backbenches. The Speaker is not involved in this. After they have agreed on it, they then get in touch with the Parliamentary Service through the clerk, who will get his officer at the table, together with the marshal, and they'll get the names, print them, and place them on the various tables as decided by the various caucuses. The Speaker don't come in. Please. How can you call Speaker to come and decide where people should sit? It's not part of my duties. Number 3. I will plead with you. Go and look at that letter. He's the Attorney General. He did his service in Parliamentary. I was leader then. Yes. When he was doing his service here. Yes. So I know him very well before he became Attorney General. Read that letter carefully. And that's one of the things they are missing. There's vast difference between Parliament as an institution and the office of the Speaker. The Speaker is the party before the Supreme Court, not Parliament. So as Speaker, when the Attorney General is taking a different position from my position, I should still contract him as my counsel. I will leave it at that. Because I'll meet the Attorney General and I'll tell him my peace of mind. On some legal issues and pronouncements he made at the Supreme Court. You know, Attorney Generals must be respected as learned. But it should not be part of what Obama referred to. Not me. It will not work. Number 4. As for the terms they use against me, it's part of the hazards of the work. We do everything as leaders, not to bring up our youth to believe that indecent, intemperate, insulting and offensive language is the way to go. But people interpret freedom of speech to mean that freedom of speech without responsibility. You can just use any word. But you know how offensive it is to you yourself or your parents when it's used against your father or mother. But for me, what I believe in is that you reap what you sow. That one, nobody can run away from it. I think the last question, I answered it. We were mindful that there's some agency for us to resolve it. They would have come together faster for us to talk, negotiate things, resolve it, and come back. But I tell you, apart from some senior citizens, patrons of the country, who actually got in touch with me, the leadership of the NDP members have not gotten in touch with me. They haven't. My good friend Oseche Mensah-Bonsu spoke to me because he wasn't even around when this thing happened. And we discussed this and I threw more light on it. And he said, oh, he didn't know before granting interviews. He said those things, but now he can also say I should bring my official report. Evidence. So, to the best of my knowledge, I don't know of the resolution of the disagreement. And so I don't know what will happen tomorrow. But I'll be available to preside. You understand? And so that is the situation now. The last question. Proposal. Proposal. Well, am I now to propose it to you and guardians? Or I should be making the proposals to the parties so that they can be negotiating and compromising? I think that's the best way to do. And I'm expecting that, in fact, I need to praise some leaders because the first to get in touch with me, I think, was Apostle Nyamiche and the boss of the Christ Apostolic Church. They were the first to come to express concern and we had a lengthy discussion. You know. Then later, a delegation of the Council of State also came to meet me in the office. And when I explained all the situation to them, in fact, many of them were really surprised because what they heard on air and what I told them and said they could cross-check from the proceedings or other things, they were really surprised, but they didn't know that was what took place. There was so much misinformation and all those, and I don't want to go into those details because they are before the court. At the end of the day, the judgment of the court will set a lot of precedent. But don't forget, the law is that the Supreme Court can always differ from its earlier decision. That is a danger. So for a purpose, I can give a judgment and ruling to favor the situation. Tomorrow, I say, no, I disagree with that. And that is permitted by law. So when you tell me that, it means that the Supreme Court is supreme. And so when it orders, I must obey. When I know the same Supreme Court can disorder, you have to raise a question. I'm a lawyer by profession. And the first time I appeared in the Supreme Court was 1983. 1983. That was my first case in the Supreme Court. I don't know whether those who are going there now were born. So, the last one is when I was young, I think when we were in the senior high, we were not calling it senior high, we were calling it secondary school. There was some song, it's too late to say that you are sorry. After you've broken my heart. When I needed you to satisfy my soul.